So this is just a quick description of the voluminous body of work and contributions that Professor Brundage has made to the American historical profession, and there's much more to come. And we have the opportunity to hear him today present on his next major project, which is entitled Reconciling American Democracy and Torture from the Age of Contact to Abu Ghraib, which is part of a book project titled Torture in American History, The Long View. Ladies and gentlemen, please join me in welcoming Professor Klement Brundage to Marquette University.
Well, whatever small measure of humility I once had is completely evaporated. That's one of the most generous introductions I've ever had. I'm sort of embarrassed. But it is a tremendous honor and privilege for me to be here, and I'm very grateful to Andrew for the hospitality and everyone. It's been, I've had I guess it's 36 hours now in Milwaukee, and it's been very pleasant. I am acutely aware that there may be other things that are of interest to you happening this evening. So I can't promise that I will get you out of here at 8:37, but I'll understand if the crowd thins. But I'll do my best. One thing that I do, one right that every speaker has, is the right to change the title. And I'm going to be talking about the same things I intended to talk about when Andrew and I first talked about this, but I've narrowed it in certain ways, and so I'd like to say that what I'm going to be talking about tonight is what I'm calling the American tradition of torture. So you know there's proper, what's the right word? The advertising and the commodity are the same. I'm going to show a clip here, and I just want to take a poll here. How many of you have seen the movie The Battle of Algiers? Excellent. Well, there's just a 2-minute clip here. If you're like me and your French is rusty, put it generously, of course we have the subtitles. So this is, I think, one of the most brilliant distillations of what it is I'm going to be talking about. Even though this was made in 1968 and it's about French imperialism in Algeria, I think you'll see, I hope you'll see by the end of my talk how relevant it is. So just to set up this scene, this is a press conference that the French colonel, who's sort of one of the protagonists of the movie, is delivering in the aftermath of the death of an Algerian, shall we say, freedom fighter. Okay. Well, maybe we'll see it.
Colonel Mathieu, le porte-parole du ministre résident, M. Borlin, a déclaré que l'artiste alpiniste s'est suicidé dans sa cellule en se pendant avec des lambeaux de sa chemise, quand il avait fait une corde, et qu'il avait ensuite attaché un carreau de la fenêtre. Or, à cause de l'intention déjà manifestée de s'évader à la première occasion, il avait été jugé nécessaire de tenir constamment de toutes les individus, mains et pieds liés. Selon vous, mon colonel, en de telles circonstances, un homme peut-il déchirer sa chemise, en faire une corde et l'attacher à un barreau de la fenêtre pour se pendre?
Cette question, vous devriez la poser au porte-parole du ministre. Ce n'est pas moi qui ai fait de telles déclarations. Pour ma part, je peux seulement vous dire que j'ai eu la possibilité d'apprécier la force morale, le courage et la fidélité de Ben Midi en ses propres idéaux. Pour cela, sans oublier l'immense danger qu'il représentait, je me sens le devoir de rendre hommage à sa mémoire.
Colonel Mathieu, on parle beaucoup en ces derniers temps non seulement des succès obtenus par les parachutistes, mais aussi des méthodes qui seraient utilisées par eux. Pourriez-vous nous dire quelque chose à ce sujet?
Les succès dont vous parlez sont les résultats de ces méthodes. Les uns présupposés, d'autres et vice-versa.
Excusez-moi, mon colonel. Il me semble que peut-être par excès de prudence, mes collègues continuent à poser des questions indirectes auxquelles vous ne pouvez répondre de qualitativement.
So torture is not used in our orders. This is obviously a press conference in which the subject is torture, but torture is the word that can't be said. And that's a theme that I'm going to be returning to in various ways. So now let me get rid of this and figure out, there we go. So, this character is someone who was one of the pundits who debated about whether torture was justified if information wrung from a tourist could prevent the catastrophic destruction of life like that which occurred on September 11, 2001. His name is Mark Bowden. He's a national correspondent for the Atlantic Monthly Magazine, and perhaps you know of him as the author of Black Hawk Down, and he also wrote the screenplay for the movie Black Hawk Down. And he's one of those pundits who, in the aftermath of 9/11, was asking the question of when is it appropriate to torture? And in a feature article he wrote in the October 2003 issue of Atlantic, he said that captured al-Qaeda operatives and other terrorists, quote, pose one of the strongest arguments in modern times for the use of torture, end of quote. He then pronounced that, quote, the Bush administration has adopted exactly the right posture on the matter. Candor and consistency are not always public virtues. Torture is a crime against humanity, but coercion is an issue that is rightly handled with a wink, or even a touch of hypocrisy. It should be banned, but also quietly practiced, end of quote. The other image here, I'll just linger on for a moment, is of course a book that Alan Dershowitz published very quickly after 9/11. Leaving aside, I'm one who finds the cover patently offensive, but so we have Osama bin Laden, obviously, and Yasser Arafat. But if you know this book, Alan Dershowitz argues that essentially we should have a system of torture vouchers that public officials could essentially get from a judge in order to use torture against a terrorist. And that would provide a measure of legal protection, but would control the exercise of torture. So this is what was going on. These kinds of debates were going on, not just on the John McLaughlin group, the McLaughlin group on television and in books like Alan Dershowitz's or in the columns of the Atlantic Monthly in 2003, 2004. Well, then, of course, came the CBS 60 Minutes broadcast of the photographs from Abu Ghraib. These pictures were too sinister to be dismissed as mere wartime hijinks. And then, this is more recently yet, were the memos. And I'll come back to these memos, the so-called torture memos, carefully crafted by lawyers to give sanction to acts that might trouble even the most dulled conscience. And this is one that I'll come back to about the definition of what is severe pain and suffering, which is central to the Bush administration's policies, and then the intent that's necessary to define torture. Well, the fevered discussion of counterterrorism methods after the September 11, 2001 attacks, the publication of photographs of prisoner abuse at Abu Ghraib prison in Iraq, and the release of the so-called torture memos written by advisors to George W. Bush sparked one of the most intense debates about torture in American history. Despite the rancor, despite the controversy that arose in the aftermath of these various exposés, if you will, both critics and defenders of Bush administration policies agreed that torture was anathema to American democracy, American justice, to American values. Critics and defenders also agreed that the attacks on 9/11 and the subsequent war on terror, to use the Bush administration's words, marked a watershed in American history. Cofer Black, who was the head of CIA counter-terrorism, has this phrase that there was before 9/11 and then there's after 9/11. This is this true break in American history, especially with regard to torture. For critics, the hysteria that followed 9/11 became the pretext for an unprecedented and indefensible embrace of torture by the American state. For defenders, the war on terror signaled the end of American naivete, when the nation finally adopted the appropriate tactics to defend itself. So in the halls of government, in newspaper columns, and in TV studios, participants in these debates declared that the United States had entered uncharted waters. History apparently could offer no lessons relevant to the nation's singular circumstances. Well, the notion that 9/11 and the war on terror marked a rupture in the history of American attitudes towards torture is, I think, a testament to the nation's historical amnesia. The recurrence of torture across centuries of American history belies any presumption that the recent practice of torture by the United States has no precedent. Americans found pretexts to commit torture long before the Cold War, before the war on terror, or before the rise of the national security state. And the persistence of torture in the United States, despite the rapid evolution of American society over the past 2 centuries, contradicts any notion that modernity is toxic to torture. But nor can torture be dismissed as a relic of the past, right? It's not some relic of some distant barbarous past. Because whenever torture has become visible in the United States, its practitioners have justified it on the grounds of contemporary circumstances, contemporary exigencies. So it's always the crisis of the moment that justifies torture. The history of torture in the United States is a history of Americans finding exceptions to the principle that torture is always abhorrent. Since the nation's founding, few Americans have endorsed torture as a routine tool of state power. It's one of those ideas that there just aren't many people who are willing to say, I'm all in favor of torture. Only when confronted by purportedly exceptional circumstances have some Americans deemed torture to be permissible. And they've done so by justifying their actions as necessary measures to defend America's unique and uniquely embattled society. So torture and democracy have coexisted throughout the history of the United States. There's nothing innate in the national character that precludes Americans from engaging in torture, nor is torture a consequence of one form of government, a particular stage of modernization, religious orientation, or economic order. Americans, however, have presumed that torture was an inherent feature of despotic and totalitarian regimes. Torture was done by them, and them could be fascist, communists, dictators, despots, etc. Not us, Americans. Nonetheless, practitioners of torture in the United States have found ways to insinuate torture into democratic institutions by appealing to democratic values. American torturers, of course, have had to ignore or reinterpret constitutional principles that protect citizens against a cruel, inhumane, or capricious state. Significant advances in social justice and expanding protections for citizens' rights during, particularly, the 20th century have created impediments to torturers. Officials, therefore, have often resorted to subterfuge to hide from public view the full extent and character of the violent coercion they have approved and employed. But much coercion, such as the violence inherent in slavery, or the brutality of police interrogations in early 20th century United States, was never fully masked from public view. And exposés of torture in the young nation's early prisons during the American occupation of the Philippines at the cusp of the 20th century, or at Abu Ghraib at the dawn of the 21st century, have failed to permanently lift the veil of secrecy. So what I'd like to do this evening is to use 3 examples to illustrate some of the conditions, some of the, what would be the right way, the circumstances that are essential to what I'm calling this American tradition of torture. And to start this story, I want to move to early 19th century Philadelphia, where the advent of progressive democracy, at least as understood at that time, promised a new era of human civilization. When Philadelphia's great and good gathered to lay the cornerstone of Eastern State Penitentiary in May 1823, they marked the culmination of a campaign for criminal justice that extended back a half century. For Roberts Vall, his first name is actually Roberts, not Robert. So if you think I'm confused, I may be, but not about his name. For Roberts Vall, a Quaker reformer, a merchant, and the keynote speaker at the dedication, the assembled crowd were witnesses to what he saw as a milestone in human civilization. The whip, the pillory, and the public gallows, quote, those cruel and vindictive penalties that pass for justice for most human history, end of quote, would now give way to, quote, milder correctives that would wisely and compassionately secure and reform the criminal, end of quote. Gentle coercion would replace the physical suffering that for too long had familiarized, quote, the mind with cruelty and hardened the heart, end of quote. Since the American Revolution, Vaux and the other founders of the penitentiary in Philadelphia had labored to develop a system of criminal justice that was consonant with the ideals of the young republic. State constitutions adopted after the Revolution, as well as the federal constitution ratified in 1789, had protected individual rights against the abuses of state power and had moderated punishments inherited from colonial legal codes. Pennsylvania's constitution, for example, greatly reduced the number of crimes that were subject to capital punishment. The Constitution also established punishments that were commensurate with the crimes for which they were enforced. So in other words, if you, I'm just making this up, but if you stole something small and insignificant, you weren't sentenced to death for theft. And finally, the Pennsylvania Constitution directed that non-capital offenders be incarcerated in prisons. This new approach to punishment, which found its fullest expression in Eastern State Penitentiary, was a major contribution to the emergence of modern human rights. Contemporaries recognized it as such, and reformers from across the United States and Europe were soon making pilgrimages to Philadelphia. As you probably know, this is what brought de Tocqueville to the United States before he wrote his magnum opus. Eastern State was pledged to provide a humane alternative to previous modes of punishment. The focus of punishment henceforth would shift from the body to the soul of the miscreant. Coercive corporal violence would be supplanted by the rehabilitation of the character of the criminal. Vaux and his reform allies viewed corporal punishment as a mark of tyranny and barbarism. And this is, of course, a Hogarth print of somebody being led to Tyburn in London to be executed. And it's a classic kind of Hogarthian scene where you see this rabble of the lower orders in all of their various, what would be the right word? In all of their various disheveled state. And it's a kind of depiction of this is not what these Philadelphia Quakers wanted to see reenacted on the streets of Philadelphia. They were simultaneously devoted to prison reform and the abolition of slavery. They saw these things as linked because both traditional criminal justice, as we see depicted here in London, and the abolition of slavery, or I should say, and slavery, employed arbitrary and inhumane violence. Where corporal punishment prevailed, they believed despotism reigned. So Vaux and his fellow reformers acknowledged that criminals would have to surrender fundamental rights, but this abridgment of their rights was justified by its intended purpose, their rehabilitation to the ranks of law-abiding citizens. Now, the rehabilitation of criminals under this new form of humane justice was possible only after prisoners were sequestered in settings conducive to introspection and penance. The removal of punishment from the public gaze was to benefit not only the prisoners, but also the body politic. Reformers, with this scene in mind, were certain that public punishment coarsened spectators. If you were in this audience, what would you make of this scene but that somehow it would celebrate the criminal? It would elevate criminals to folk heroes, and it would fail to instill respect for law. As you probably know, there was no better place for a pickpocket to work in London than at an execution. So, in the place of a spectacle like the whipping post or the gallows, reformers looked to the terror of solitude, made possible by the architectural design of the penitentiary, to render corporal punishment superfluous and to reform erstwhile criminals. Beginning with the first inmate who was incarcerated in Eastern State in October 1829, a regime of solitary confinement dictated both the prison's design and its schedule. The layout of the prison was intended to foster a church-like atmosphere, and there's the floor plan. As you probably know if you've read Foucault, any of you have read Foucault, this is, Foucault runs with this. This is the panopticon for you, or a version of the panopticon. So this layout was intended, as I said, to foster a church-like atmosphere. The cells were made here. I'll give you a shot of the hallway down one of the, with all of the cells coming off on either side. And here's an image of one of the cells at Eastern State. And it should be said that this has obviously not been restored, so they didn't actually look like that when they were. Yeah, they didn't have commodes sitting in the middle of the floor quite like that. The cells were made of concrete with the single glass skylight, which you can see there at the top, which represented literally the eye of God and God's implicit supervision of their rehabilitation. The cells were only accessible through those doors that you saw on the earlier picture that were covered with heavy wood to filter out sound. So you can imagine when you're actually in these cells, they're very quiet except for whatever sounds you yourself or as a prisoner would make. Except for brief periods each day, when prisoners had access to these private exercise yards, they were kept inside their cells. These exercise areas were enclosed by high walls to prevent prisoners from communicating, and their exercise times were synchronized so no two prisoners were in the same space at the same time. Whenever prisoners left their cells, they were wrapped in hoods and they were accompanied by guards. While advocates of Eastern State's methods believed fervently that criminals held in solitary confinement would become genuinely penitent, the prison staff quickly introduced physical coercion into the prison regime. Less than 5 years after the prison opened in 1829, a crisis there demonstrated how difficult it was to calibrate punishment so that coercion in the name of rehabilitation did not give way to cruelty that contravened the principles of enlightened justice. The laws that regulated the penitentiary granted the keeper authority to reward and punish prisoners by, for example, increasing or reducing their work or food. Well, I think you can imagine that was a slippery slope. And more severe forms of corporal punishment were also allowed. Over time, the guards and counselors in the facility designed a variety of physical and physiological tortures to punish unruly inmates, including dousing them with ice cold water. I'm sorry this image is so far down here, but there's water running down on an inmate who's pinioned, or whatever the right word would be. So they were doused with cold water outside during winter months. So they were chained with their tongues to their wrists so that if they moved their wrists, they tore their tongue. And they were also put in straitjackets and strapped in chairs so that they were immobilized for days. And they were confined to a pit called the Hole, where they had little food and no light or human contact for up to 2 weeks at a time. Rather than rehabilitation, these punishments produced intense suffering and, in a few instances, death. And that's what helped to provoke this controversy in 1834. Many contemporaries trace the cruelties at Eastern State to the personal failings of Samuel R. Wood, the penitentiary's overseer. Even one of the sternest critics of Eastern State agreed with this conclusion. Quote, "The fault lies not in the system, but in the maladministration of the system." Wood almost certainly was a flawed administrator, but he displayed few of the traits of those Hollywood prison prison directors of so many Hollywood movies who are really dark, sinister characters. He was a businessman by occupation, but he was an earnest Quaker, as well as a very prominent supporter of the anti-slavery cause and the Philadelphia's prison reform movement. The cruelties that his regime inflicted were as much a consequence of the new philosophy of rehabilitation as of the shortcomings of his leadership. The impulse to move away from the infliction of punishment upon the body toward the reformation of character created daunting challenges for Wood and his aides. How could you discern whether a prisoner had actually internalized the prison's discipline? Right? Because it's not good enough that they just do it. They have to have been, their soul had to have been rehabilitated. How could you be sure the prisoner's reformation was sincere? What countermeasures should be applied to prisoners who resisted rehabilitation? Or what do you do in a prison where 24/7 there's supposed to be silence and you have a prisoner who won't be silent? Predictably, penitentiary staff became fixated on eliciting evidence of submission from incorrigible prisoners. Well, defenders of Warden Wood dismissed the charges of cruelty by stressing the context in which the Quaker reformer labored. They pointed out that the gag, the straitjacket, and shower bath and other disciplinary devices adopted at Eastern State were also employed in asylums and hospitals at the time, where specialists sanctioned their use. So none of these punishments were out of the ordinary in the early Republic or in early 19th century Western Europe. Solitude, moreover, sometimes needed to be supplemented. When solitude and a prisoner's conscience failed to promote rehabilitation, the only recourse was sterner measures inflicted on the prisoners' bodies. Wood's allies insisted that charges of cruelty directed at Eastern State were misplaced. Only those familiar with the penitentiary population were qualified to judge the appropriateness of the methods used to overcome insubordination. The punishment of criminals was best left to the discretion of the prison staff in the privacy of the penitentiary. Well, what do these events in the early years of Eastern State tell us? Americans in the new republic presumed that citizens would be free from the threat of torture. But the constitutional guarantee against violent coercion was never absolute or universal. The constitutional protections against cruel and unusual punishment were contingent. Among the far-reaching and significant innovations pioneered at Eastern State was the principle that society had the prerogative to deprive criminals of the rights and protections accorded to citizens and to make the return of those rights contingent upon subordination. That the nation's preeminent prison reformers reached this conclusion is noteworthy. And I want to point out this is the cutting edge of prison reform in early 20th century Western society. At least in the eyes of the public, who displayed little obvious sympathy for the victims of torture at Eastern State, prison reformers had successfully distinguished between the discipline of the prison from the arbitrary and cruel power of the slave master or earlier systems of criminal punishment. So although Eastern State had adopted practices that mirrored those of despots and slave mongers, its defenders nevertheless insisted that the punishments at Eastern State were different. They weren't inspired by cruelty, but rather were reluctantly imposed out of necessity. Indeed, responsibility for coercive punishments at Eastern State ultimately lay with insubordinate inmates. So now I'm going to quickly shift us to the early 20th century and to the cases of Ed Brown, Henry Shields, and Arthur Ellington in Kemper County, Mississippi. And this is a news clipping that just relates to Ed Brown. Brown, Ellington, and Shields were young black sharecroppers suspected of murdering a well-regarded white planter in 1934. Even before the men were incarcerated, rumors of a lynching attracted large crowds to Meridian, Mississippi, which is the closest town to where the murder happened, and was the town where the suspects, these 3 black men, were held. Within a day, newspapers reported that the alleged black murderers had confessed their crime and plans were made for their speedy trial. With the trial date set for less than a week after the murder, and with a date of execution discussed even before the trial, local newspapers predicted that lynching could be averted if the suspects were swiftly convicted and executed. The district attorney in this case, come on, why is it? Oh, I know why, I'm clicking the wrong button. The district attorney in this case, this gentleman over here will be a name that means something to some of you, is John C. Stennis, who would serve in Congress from Mississippi for most of the 20th century, it seemed. Well, he was then a young district attorney. This is a picture of him in 1948, so this is 14 years before. He was then a young district attorney at the beginning of his long political career, and he was committed to securing swift justice for, quote, the confessed murderers. On the day of the trial, the 3 defendants met their court-appointed lawyer for the first time, 20 minutes before the trial began. And the trial opened in, there's a reason why I'll show you this picture. This is the Meridian Art Deco courthouse where it happened. I show you that mainly so that you don't think of this as being like the movie version of To Kill a Mockingbird. You know, there's that courthouse and it's hot and it looks like it's out of the 19th century. So this was a brand spanking new modern Art Deco courthouse. John C. Stennis, a young up-and-coming district attorney, there lingered at length on the men's confessions for the simple reason there was no other corroborating evidence other than the confessions to link these 3 black men to the alleged murder, or to the murder. There's no question there was a murder. The case might have unfolded like countless other cases in the Jim Crow South, except that the defendant's public defender, a white lawyer, became increasingly disturbed by his client's testimony. Remember, he had never met them till literally just before the trial. Yes, they admitted they had confessed to the murder, but they explained they had confessed only after they had been repeatedly beaten and whipped in the Meridian jail by a deputy who, not coincidentally, was a close friend of the murdered white planter. All 3 of the suspects had been fearful that they would be killed either by the deputy or by a lynch mob, and one of the 3 black men had nearly been lynched while he was being taken to jail in the first place. So when District Attorney Stennis suggested that Ellington's fears of the sheriff and his deputies were unfounded, the deputy with good cause shot back, "I'm scared of all white people." Despite the deputy's ready admission, the deputy then, the defense lawyer, called the deputy to the stand, and he readily confessed, "Oh, I beat them many times. Beat them almost to the point of death." Despite that, an all-white jury deliberated for less than 30 minutes before returning guilty verdicts against all 3 men. Now, lest you conclude that the treatment of these 3 black sharecroppers in Mississippi was just another manifestation of Southern injustice, and it was that. I certainly don't want to deny that. I want to shift momentarily to another case. This is the case of Tony Klement, who 4 years earlier, so 1930, and 800 miles north of Kemper County, was interrogated by Cleveland police, Cleveland, Ohio police. Klement was 18 years old when he was picked up following the murder of his wife. And there's the clipping announcing her death. And in fact, this is the story that you'll see how it figures back in this account in a moment. He then experienced routine American police interrogation. And just to get this across, this is, of course, a classic scene from a film noir of the Third Degree, which is what I'm talking about right now, police interrogation. Well, even though Coletti had agreed to questioning at the police station, officers subjected him to 26 hours of interrogation, straight interrogation, during which they deprived him of food and water, they stripped him naked, they forced him to stand in stress position for hours on end, they punched him repeatedly in the ribs and in the lower abdomen, and they beat him with a rubber hose until he agreed to sign whatever confession they placed in front of him. So badly beaten was he that he was unable to read and understand the confession that he signed, and it is only when he read that news story that you saw, or a news story like that, I don't know which one he read, but it's only when he read the newspaper after he was confined in jail that he came to understand that he had confessed to his wife's murder. Well, as the experiences of Coletti, Brown, Shields, and Ellington suggest, the practice of wanton torture during interrogation had become a routine tactic of police, of law officers across the country during the early 20th century. Ignoring the Fifth Amendment, which, as you'll remember, protects citizens against self-incrimination, and the Eighth Amendment, which forbids the use of cruel and unusual punishments, the professional police forces that proliferated during the late 19th century justified the resort to the, quote, third degree with assertions of the incorrigibility of hardened criminals. The nation's loosely structured judicial system offered few checks against such coercion. Opposed to a centralized state, the authors of the Constitution had dispersed political authority so that virtually every state power was constrained by a countervailing power. Moreover, with sovereignty resting with, quote, the people, the federal state garnered only limited powers, while the remainder were assigned to state and local authorities. On the local level, power was further dispersed, so that most communities, certainly many communities, had several police forces with overlapping jurisdiction. This devolution of power to local interests ensured that the nation's police departments, which invariably were intensely local and highly politicized, operated free of almost any judicial or legislative oversight. Now, let me linger on this point just a little bit longer. Although the 14th Amendment to the Constitution, which was of course ratified in 1868, established the framework for the protection of citizens' rights, federal courts were loath to extend those protections until the mid-20th century. As a result, during the late 19th and certainly the first third, and perhaps almost to the first half of the 20th century, the expanding powers of local police were largely unconstrained by any guarantees of civil rights. For all practical purposes, the most significant constraint on police interrogations was law officers' consciences. The American judiciary studiously avoided any acknowledgement of torture or its import on the pursuit of justice during this period of time. Brown, Shields, and Ellington's confessions, for instance, had been coerced outside the purview of the judiciary. And so the presiding judge, who heard testimony in his own court that acknowledged that those confessions had been gained through coercion, elected to overlook the extralegal methods used to extract them. So again, although court testimony subsequently established their confessions had been coerced, the judge sentenced the men to death. In this instance and countless other, judges were knowingly complicit in the practice of the third degree whenever they admitted coerced confessions as evidence in their courts. And I want to stress, this was happening all over the country. This was as pronounced in Seattle, in Chicago, in New York City as it was in the South. The constitutional ban against torture in some stood at odds with the dispersed authority and limited protection of civil rights that prevailed for more than a century and a half after the nation's founding. Now, eventually, exposés of the prevalence and severity of third degree aroused mounting opposition from civil libertarians, civil rights activists, and the broader citizenry. In 1930, the publication of a major investigation, which had been conducted on behest of Congress, led to the adoption of important reforms that inhibited some of the traditional police practices and at least temporarily put law officers on the defensive. Simultaneously, returning to the case of Brown, Shields, and Ellington, the three black sharecroppers in Kemper County, Mississippi, they actually brought an appeal, which eventually ended up in the Supreme Court, and a landmark court decision that enabled the three men to escape the hangman's noose and that laid a foundation for constitutional protections against coerced confessions that would be expanded in subsequent Supreme Court decisions. But in spite of the stricter standards for interrogations and confessions that were established by the Supreme Court in this and subsequent cases, instances of police torture, now renamed police brutality, have persisted to the present day. As you probably know, there were long-running and widespread uses of torture in New York City, Chicago, and Los Angeles just in the last 20 years, Chicago being perhaps the most extreme and notorious example. Greater scrutiny of police brutality by the courts and public oversight commissions almost certainly will be insufficient as long as the dispersal of state power in the United States perpetuates conditions conducive to torture while impeding the effectiveness of sanctions against it. And so now I want to turn to the issue of torture during the peak, if you will, the height of American global power. And so here I want to start off with an episode, an obscure episode in 1966 involving a character by the name of Dr. Lloyd H. Cotter, who was a California psychiatrist, and two unnamed CIA staff physicians, or staff psychiatrists, I mean, who traveled to South Vietnam in 1966 to experiment on patients at a mental hospital outside of Saigon. Their public mission was to test whether electroshock, and of course I had to find a photograph of an electroshock machine. One of the great virtues of eBay is you can not only find photographs of electroshock machines, you can even buy one if you want one. But in any case, an electroshock, they were testing whether electroshock coercion would alter human behavior outside the laboratory. Again, this is one of those things where you sort of say to yourself, do you really need to have people paid to... I can predict the outcome of this. So for several weeks, Cotter applied electroconvulsive treatment to mental patients with the goal of coaxing them to work. Apparently, patients preferred to comply rather than endure further treatment, leaving Cotter, quote, impressed with his results. Well, at the same time, the CIA psychiatrist subjected several Viet Cong prisoners, held secretly in the same facility, to as many as a dozen electroshock sessions each day. The goal of breaking down the prisoners' morale and gathering intelligence from them was thwarted when one by one the procedure killed them. With no subjects left upon which to experiment and having gathered no intelligence, the CIA operatives packed up their electroshock machine and returned to the United States. Well, this failed application of modern science to interrogation was obviously a minor event in a decades-long campaign by the United States against global communism. Yet it's also a telling illustration of the deep-seated contradiction at the center of the United States stance on torture after 1945. During the Cold War, the United States simultaneously urged on international campaigns against torture while employing torture as a tool of American international policy more broadly than at any previous time. Following World War II, the United States stood behind the proposition that torture violated fundamental human rights. The nation, represented by Eleanor Roosevelt, played an active role in the drafting and adoption of the United Nations Universal Declaration of Human Rights in 1948. In the charged milieu of the intensifying Cold War, denunciation of torture figured prominently in American foreign policy and would continue to do so into the 1970s and the early 1980s. Appalled by apparent displays of psychological manipulation during show trials in Eastern Europe and Stalinist Soviet Union, Americans concluded that torture was an inherent feature of totalitarianism, and especially communism. At the same time, the perceived stakes of the struggle against international communism convinced many policymakers that extreme measures were not only justified but also necessary. During the Korean War, for example, American officials and the broader public were shocked when captured American pilots, these are American POWs during the Korean War in China, confessed, in quotes, on Chinese newscasts that they had committed war crimes. That 70% of American prisoners held by the Chinese confessed to war crimes seemed to indicate the extent and success of Chinese brainwashing techniques. And it's really in that context that the whole idea of brainwashing sort of entered the popular culture of America. A spate of popular books and magazine articles contrasted communist advances in psychological warfare with the inadequate countermeasures of American officials and scientists. There were some Americans who, of course, called for strengthened international protocols to defend human rights. So let's stop China from doing this. But there were others who urged American planners to master the enemy's techniques of coercion. So sustained by the conviction, and this is a quote from a founding document, we must learn to subvert, sabotage, and destroy our enemies, lest they destroy the United States. American politicians in 1947 began building the national security apparatus, including founding the Central Intelligence Agency, the CIA, which was vested with impressive powers, sustained by ample funding and shrouded in secrecy. Soon after its inception, the CIA was authorized to launch, quote, covert psychological operations. Now, I won't, there are good histories, there are interesting books to read about the evolution of the counterintelligence measures, the covert psychological operations that the CIA pioneered in the 1950s. So I won't recount them, but I do want to get to the fact that by 1963, the CIA had distilled this research in, quote, covert psychological operations into a secret but widely disseminated handbook, interrogation handbook. Among its crucial findings was that sensory deprivation, in the words of a Princeton psychologist, and as you may know, it's a who's who of prominent psychologists of the 1950s and early 1960s who were working for the CIA one way or another. When the words of a Princeton psychologist, sensory deprivation offered, quote, a very effective brainwashing technique. Careful studies of communist methods also disclosed that, quote, self-inflicted pain was strikingly effective in breaking down prisoners' resistance to interrogation. In other words, stress positions were a great way to break down resistance. So it wasn't necessary any longer to beat the prisoner. You could put them in a stress position for 10 hours, and by the end of 10 hours, and deprive them of sleep for several days, and keep them freezing cold, and before long, they'd start to tell you what you wanted to hear. Finally, a notorious study by Yale psychologist Stanley Milgram, who recruited workaday New Haven residents to inflict what appeared to be painful electric shocks to anonymous subjects, demonstrated that ordinary citizens, when properly coaxed and when given apparently authority, were willing torturers. So, in other words, they worked out how to torture without seemingly torture and how to get people to be torturers who might otherwise not be torturers. And all of this was summarized in this wonderful work that, of course, thanks to the internet, you can all download at your discretion. The Kubark, if you don't, there's no reason why would you. That's one of those curious kind of Cold War cryptograms. That's what the CIA called itself. I don't know what purpose it served to call it the Kubark. But in any case, the other interesting things down here, it says, not for distribution. They distributed this to every third world totalitarian regime on the face of the planet eventually. So By the time that it actually made it on the web, it was already very well known. Well, just if you look through the table of contents, you can see they outline all of the various aspects of how to identify your interrogator, how to do all of that, and then eventually we start getting to the really quote unquote interesting stuff, and here's where you see exactly how they pioneered, if you will, and actually it's not pioneered, it's codified these techniques. Well, the point of this, what I'm really getting at is, by 1963, the CIA had worked out a way to come up with torture that no longer involved the kind of crude physical torment that had characterized earlier forms of torture. And so during the next 3 decades, during the battle against communism in the Third World, the CIA would use the Third World as a testing ground for each of these techniques. CIA agents shared them with client states, especially in Latin America and Southeast Asia. And while doing so, they convinced themselves and those they trained that they were not employing torture, but rather cutting-edge, modern, and legitimate interrogation techniques. Now, ambiguities and contradictions in American policy on torture would persist throughout the remainder of the 20th century. The United States committed itself to suppressing torture by ratifying the UN Convention Against Torture. The U.S. passed the Protection for Victims of Torture Act, and it legislated in 1996 the War Crimes Act. The U.S. military revised its interrogation techniques in accordance with these new treaty obligations and laws. And yet the United States remained deeply implicated in international torture as a result of both the Reagan administration's training programs for client states and client states' counterinsurgency forces. Some of you may remember in the 1980s and especially 1990s, the School of the Americas, it was really the 1990s, the School of the Americas at Fort Bragg was a major focus for campaigners for human rights, because that's where the U.S. military brought Third World military officials to be trained in interrogation. In any case, so the United States was still deeply implicated in international torture as a result of the Reagan administration's policies, but also the Clinton administration's policy of torture by proxy. Following the first al-Qaeda attack on the World Trade Center in 1993, national security advisors had recognized they had really bad human intelligence about Middle Eastern terrorists. And so they were desperate for new and timely sources of intelligence. So the CIA began kidnapping suspected terrorists in the Balkans and turning them over to Egyptian authorities for interrogation and torture. During the remainder of the Clinton administration, at least 70, quote, non-state actors, as they were called, were subjected to extraordinary rendition rather than formal extradition. As you probably know, extraordinary rendition is illegal. It contravenes international law, but nevertheless, it was done. So these are people who are literally snatched off the streets, taken first to Egypt and then to Syria, Saudi Arabia, the Philippines, and elsewhere. Through this program of extraordinary rendition, the United States intelligence community secured intelligence while the interrogators in other countries, as a Filipino interrogator put it, quote, did the dirty work, end of quote. So after the 9/11 attacks, the Bush administration had to sort through these contradictory policies. On the one hand, they have the United States publicly committed to combating torture. And on the other hand, we have these, shall we say, furtive practices that were going on. In order to wage their war on terror, they had to figure out how to resolve these apparent contradictions. Well, a combination of political influences, ideological commitments, may explain why the Bush administration elected to ignore some precedents regarding torture while favoring others. Bush staffers were acutely aware that they had held the reins of power when the nation suffered its worst terrorist attack. If voters concluded that the administration was incompetent or negligent in protecting the nation, the consequences for the presidency and the Republican Party would have been catastrophic. So, several prominent members of the Bush administration were certain that, of course, the response would be as, how would I put it, as vigorous as was conceivable. Other members of the Bush administration viewed the constraints imposed on American intelligence agencies during the 1970s and the 1980s as excessive and contrary to national interest. Need I mention names here, but one that comes to mind is Vice President Cheney. So the war on terror provided a pretext to roll back those reforms. And then there was, of course, the understandable intensity of public anxiety. And that's where I come back to those quotes, the very first quote that I opened up with by the journalist, about unpredictable terrorist threats. And of course, there was all the talk about nuclear dirty bombs, about chemical weapons attacks, plane hijackings, et cetera, et cetera. The important point is that the Bush administration didn't innovate policies for the use of coercive methods. It didn't have to invent policies so much as it had to refine and formalize extant policies. Extraordinary rendition and torture by proxy were already established American policy. All the Bush administration did was expand them tenfold. And I say all, and I don't mean that sort of, yes, it is a change in scale that's very important, but the policy had already been established. The CIA already had a half-century of expertise in coercive interrogation. Now the agency would employ its expertise in carefully chosen locations outside of the jurisdiction of American law. So the Bush administration's principal innovation in the policy of enhanced interrogation was its legal justification intended to protect American operatives from national and international sanction. Now I just want to briefly address these by turning to those. I realize we're getting real close to, the first pitch might have already been thrown, so I'm very conscious of time here. But the rationales of the President's legal advisors, I think, rest on three claims that I just want to briefly touch on here. The first is, of course, the administration decided that the people who would be subject to enhanced interrogation were enemy non-combatants. And this idea of that the important point is that they're not conventional prisoners of war. And so therefore they were not protected by the Geneva Conventions the same way they would have been if they had been prisoners of war. This was a very, this was an area where you could see the Bush administration was facing a problem of definitions where there are good, sound reasons why they could have come down the way they did. But the important point is that once they concluded that the rules of civilized conflict didn't apply in Afghanistan and Iraq when confronted by Al-Qaeda, then the administration had opened up for itself a whole realm of possibilities in what forms of interrogation were therefore possible. So as I said, at first glance, the idea of doing this was inherent in the confused situation of dealing with non-state terrorists, if you will. But it also created a challenge for the administration to try to figure out the precise boundaries of where enhanced interrogation turned into torture. And at first glance, you would assume this is prudent, right? You'd want, if you're going to establish boundaries, you want to figure out precisely where they should be. You go this far and no further. But it appears from the torture memos, as I'll suggest in just a moment, or as I'll demonstrate, I hope, in just a moment, that the apparent intent was to provide operatives with legal permission to adopt the harshest conceivable measures that were just short of a very narrowly circumscribed definition of torture adopted by Bush administration officials. So, and here, I don't know, it's probably hard for you to read, but you can find the so-called torture memos online. This is a very, very interesting passage where what's being decided here is what is the definition of life-threatening torture? Anything that isn't life-threatening ultimately is not torture. And so methods of interrogation that fell short of organ failure, impairment of bodily function, or even death did not rise to the level of torture. Neither did psychological coercion unless it was, quote, of significant duration lasting for months or years, end of quote. So the point of this document was that only, quote, extreme acts were banned, were prohibited. The final claim that the Bush administration came up with, that torture could only occur when the explicit intent of the interrogator was to commit torture. In other words, and here's the document that spells this out, specifically intended. In other words, if an interrogator caused pain while eliciting information from a prisoner, then the intent of the interrogator was not to engage in a forbidden act of torture, but rather to gather intelligence. Only in those instances when an interrogator, quote, acted knowing that severe pain or suffering were reasonably likely to result from his actions, would an interrogator commit a violation of the law. By this understanding, an interrogator could engage in acts that had every appearance of being torture, but because the severe pain that those actions produced were only a consequence of gaining intelligence, rather than the specific intent, he was not engaged in torture. I hope you can see the resonance to what I was talking about at Eastern State, where they weren't engaged in torture there. Even though it looked like torture, it wasn't torture, because that wasn't their intent. This redefinition virtually defines torture out of existence, at least as long as it's committed by the right people with the right motivations. Taken together, these three claims that were laid out in the torture memos all rested on the notion that American values and motivations virtually by definition prevented Americans from engaging in torture or systematic violations of human rights. All right, so I know it's time for me to wrap up here. Well, it's only willful denial that it can explain Americans' refusal to acknowledge the full extent and character of torture carried out in their name. Since the nation's founding, the question of whether torture has a place in the nation's affairs has vexed generations of Americans. Each time, and I could talk about different moments in time when there have been rather vociferous debates over torture. Each time the debate has flared, Americans have displayed little awareness of the nation's tradition of torture. It's like we have to rediscover its existence each time. Instead, after each expose, Americans have eventually tired of the controversy, turned their attention to other matters, and left the nation's stance on torture unresolved until the next bout of introspection. Faith in American principles, institutions, and leaders has discouraged forthright acknowledgement of torture, as well as vigilance against it. To acknowledge torture in the last best hope of earth, as Abraham Lincoln baptized the United States, would be to impeach the most hallowed ideas about the nation's uniqueness and historical significance. And on that note, I want to make sure I end, so those of you who don't have your DVR recording the game can hustle out, and those of you who have questions you want to throw my way, by all means, please do.